Commission meeting for Wednesday, July 12th, 2023. The first agenda item is open forum. Before I open it up, Noel Donovan is with us on the phone, so all votes will be roll call votes. Do any commission members have something for open forum? Matt?
I just have one announcement that was shared at the select board meeting last night. The town was awarded a $500,000 EPA cleanup grant for 12 North Main, so I anticipate some further remediation efforts will be occurring out there, hopefully sooner. But that was a big get by the town manager's office who put in for it.
Now, is that related to the miscellaneous item in our packet? Yeah.
The report.
Last 200 pages?
Yes.
Site remediation?
Yes.
Okay.
Yeah. It is related to it, but it's not. They were two independent. The LSP submitted their kind of year-end report. Documenting all the bills of lading. Things we were asking for, but also the grant is able to continue that effort going forward. So I thought that was very exciting.
Do members of the audience have anything for open forum? Oh, okay. Let's move to our next 7 p.m. agenda item, which is a request to serve alcohol at an event and a request to waive rental fee by the Friends of East Boston Camps.
I can take this one as the representative from the Friends of East Boston Camps who was planning on attending, had a family emergency and was unable to attend. This is a regular request from the Friends of East Boston Camps to serve alcohol at their gala event this fall, and also request the commission waive the rental fees as well. If there are any questions, I'll try to answer.
I'm good for the rental waiver, and as far as alcohol, it's going to be in the dining hall only, not outside?
Yes, it's in a specific location. They have a vendor, and their name escapes me, but it's tips,
okay.
tip certified. Right.
They have been doing it.
Okay.
Right. Yeah, exactly. Right. And I think it's the other kind of item is usually limited liability insurance is obtained and
Okay.
On file.
Sounds good.
Okay. So that will all be in your, assuming we vote in favor, that will all be in your reply to Marcia?
Yes, and I'll probably copy the town manager's office because usually that's where the alcohol request. The select board is the one who issues the one-day alcohol license, so I'll forward that along to them as well.
Okay. Can I have a motion to approve the request to waive the fees and for the gala?
I just said second. Sorry.
Either way.
Okay. All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Anne?
Yes.
And Margaret, yes. So that's done. Okay, and then the other 7 p.m. agenda item is continued public hearing and issue order of conditions for Great Elm Way.
This was a public hearing that was back before the commission a couple, 2 meetings ago. It was for the removal of 2 pine trees in the bordering vegetated wetlands and bordering land subject to flooding. At that time, they had not received a DEP file number. At the last meeting, they had not been issued a DEP file number. We have since received a file number 334-1833, and I think there were just minor clarifications that we included in this updated in the updated special conditions, such as the certificate of compliance was issued.
Any comments or questions on the orders that were in our packet? Can I have a motion to issue the order of conditions as written?
So moved.
Second?
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Anne?
Yes.
And Margaret, yes. So can I have a motion to close the public hearing?
So moved.
Second?
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Anne?
Yes.
And Margaret, yes. So That is taken care of as well. Moving on to our 7:05 PM agenda item. Public hearing to amend order of conditions for the Littleton Clean Lakes Committee and Friends of Forge Pond.
Jim, there should be a legal notice.
Yep, it's underneath. Okay.
Sorry.
Under Mass General Law, Chapter 131, Section 40, the Wetlands Protection Act, and Westford's non-zoning wetland bylaw, Chapter 171, the Westford Conservation Commission will hold a public hearing on Wednesday, July 12th, 2023, at 7:05 PM in Meeting Room 201 at Town Hall, 55 Main Street, to consider the request to amend the order of conditions, DEP file number 3341714, by the Friends of Forge Pond, to allow the use of physical harvesting of plants as a method of controlling invasive and nuisance plant growth, in addition to drawdowns at Forge Pond.
Hi, I'm Dave Barr. I'm a member of the Westford Health Lakes and Ponds Collaborative, Littleton Clean Lakes Committee, and Friends of Forge Pond. So for the last 10 years, the Friends of Forge Pond and Littleton Clean Lakes Committee have been doing drawdowns in the winter to try to manage the invasive plants in Forge Pond. And it's variably effective. There's limited control we have. We can open the stop logs and sluice gates at the Abbott Mill Dam, and we do that up until the end of November, and then it's kind of up to Mother Nature and beavers as to whether we have a very effective drawdown or not. For instance, last winter was very warm. The lake never actually fully froze over. And so in order to have an effective drawdown, you need 2 weeks of sustained below freezing temperature, which we didn't have. And it also needs to be low. And we didn't have that either, because instead of snow that stays on the ground, we had rain that washes into the lake and it raised. So as a result, this year the plant growth in the lake is very high, much more prolific than usual. People are having a lot of problems. It causes problems for swimming, for fishing, for boating, and anecdotally, one of the people that participated in the July 4th boat parade going around the lake once, they had a weed ball on the back of their propeller. It was about the size of a basketball that, just going around once. And it's growing up in places that normally it doesn't get to the surface also. In addition to that being a problem currently, it can lead to bigger problems in the future. The invasive plants that we have on Forge Pond, variable milfoil, Eurasian milfoil, fanwort, curlyleaf pondweed, and Eurasian naiad, all can be propagated by fragmentation, where pieces of the plant float elsewhere, and then when they land someplace, they take root, and becomes more of a problem. And when we have more plant growth, especially out in places that are further from the shore than normal, as the boats go around the lake, they chop it up, and we have a potential for more problems. So in the past, we've considered other ways of managing the plant growth. We don't really want to do herbicides because we feel like there are specific problems with that. We haven't felt like physical plant harvesting has been practical or economically feasible, but there's new to us process, eco-harvesting, that we would like to try this year. We tried it, Clean Lakes Committee tried it on one of the lakes in Littleton last year, and it worked well. And it's pretty economical, and it has an advantage over something like hydro raking, that it contains the plants that are collected, and it's put onto a pontoon boat type boat with sides and contained, and then taken to shore and put onto a trailer and removed for disposal elsewhere. It was described in some detail in the narrative. So we'd like to try that. We are asking for general approval for general physical plant removal to allow for flexibility in the future if there are other kinds of physical plant removal that seem to be appropriate in the future. When we approached Jim and Amy Green in Littleton, the suggestion was that rather than create a separate notice of intent for physical removal of plants from the lake, that we amend the drawdown order of conditions and start to create sort of a comprehensive lake management process, which would include currently drawdowns and potentially physical harvesting, and potentially, if we get past the pilot project phase of benthic mats, could include benthic mat use, sort of as a overall, rather than separate individual approvals and expiration dates and management issues. So that's what we're doing. We're asking for to amend the existing order of conditions for the drawdown to include physical plant removal. And specifically this year, we'd be doing eco-harvesting, hopefully. But we are looking for sort of the broad category. So that's where we are, and can answer any questions.
Okay, Jim?
I noticed in the package that the plan is for 2 days of mechanical harvesting. One would be in the Littleton areas and one would be in the Westford areas. That sounds fine. My question... each year? Okay, whatever.
That's the plan for this year.
Okay.
Yeah, it might be more another year, depending on what's
Okay.
needed and what kind of funding's available.
Is that going to be coordinated with the drawdown so that it happens at the same time?
No, it would be this, so the plant removal would happen in the summer, in the season, when the plants are, when the plants are. This particular process can get within, the top foot or so of the surface, maybe a foot and a half.
That's all it will harvest down to a foot?
So it has that drum on the front that turns, and then there's a conveyor belt underneath, and as this turns, the conveyor belt turns, they kind of squeeze the plant between them,
the ramp.
and it carries it up the conveyor belt into the hopper. But there are some harvesting methods that cut the plants, and then just the top part, whatever they cut is taken off. This, they're trying to pull it up in a gentle way that can get the whole plant. I think that's variably effective in terms of getting the whole plant, just from, practical experience and depending on how deep the water is and what kind of plant it is. But that's the idea, and so it's being done in the summer when the plants are most present.
So July, August.
Yeah. The plan was to do it in late July. That was the Littleton Clean Lakes Committee is doing it this year on all of, 3 of the lakes in Littleton, 2 for sure, hopefully a third. And the agreement was to do it in late July. When the contract was completed, it turned out to be early July, and tomorrow they should be finishing Spectacle Pond, and then moving on to Long Lake, which will probably take at least a week, maybe a little longer. And then, at that point, they'd be ready to move on to Forge Pond. So that's a bit of a disappointment for us, because if it was as planned at the end of the month, then we would have a better chance of having all of our approvals in place and the waiting periods in place and all of that, while the company doing it was still here, just finishing, and then they had agreed that they can move on to this lake.
Okay, so summer harvesting, winter drawdown, still the plan.
So in the worst case, we don't get all of our approvals in time with the early schedule that they've put in place for this year, and we might not be able to do it this year. We could potentially have them come back. They're only in Connecticut. But then there'd be extra charges for transporting the machines twice and all of that, so it's not clear that that's actually feasible. So we're hoping there's another wrinkle that we can talk about in terms of natural heritage, might push us out further too. If you want to talk about that at some point.
Eric?
Sounds like what they want to do is be able to, use this machine to remove invasive weeds and vegetation from the lake where they see it. Typically in the past, people have said, we want to, if we're doing a pilot or experimenting, we want to do it in these locations, we want to check the effectiveness, and then we let them do more. I look at this and I would say, I see what's going on. The only thing that concerns me is are we causing fragmentation by using this that's actually going to spread things like Eurasian milfoil, which has always been an issue. And I just don't want to have the method employed that's trying to remove invasive weeds, kind of lend to spreading them throughout Forge Pond.
Right.
And that concerns me a little bit. Other than that, I guess I prefer to know what areas were going to be treated, and we typically had a little more information on what was where before we let people go forward, and this seems to be a general, as our whoever's going to go out and do the work, as our contractor sees fit, they're going to try to remove it. Typically, we would want a little more than that.
Dave, with activities in prior years in Littleton, have there been annual reports that talked about locations, the results of the harvesting, stuff like that, in terms of giving us more of a detailed understanding of how they pick the areas to work? Because some of it may be, until you get out in the lake, you're not quite sure where the heavy infestations are. But are there annual reports from prior years' process in Littleton that could be informative to us?
No.
Okay.
But I mean, I can respond to two of your questions, right? In terms of, so Littleton did a pilot project last year on Spectacle Pond, only on Spectacle Pond, to see how it worked. I went over for several days while they were doing it, and went around with the president of their lake association while they were doing it for a couple days, and then went back a month later to see what had happened. And to respond to your first question about spreading, for hydro raking, that's a real problem, right? And we are reluctant. There's a group on the lake that has done hydro raking in the past, which we haven't endorsed, but they have a permit to do it in Littleton. They haven't been doing it for the last 2 years. That definitely spreads. It contains maybe, I would say, half of what they scoop up. When I observed it, it really contained everything. There was, as we were, motoring around them, watching them for, a full morning, it really didn't have plant material floating away. The roller in front and the conveyor in the bottom pinch the plants as it's being pulled, and then it goes up the conveyor belt. The conveyor belt has sides on it to keep the plants from falling off the conveyor belt. It goes into a hopper in the vessel, and the hopper has sides that are probably 2 foot high, which contain it, and once the plants get filled up to that point, they stop, and so that contains it. So in my experience, that's good. When they put it onto the trailer to remove it, the trailer's on the shore, they lift the conveyor belt above and into the trailer. They reverse the motion of the conveyor belt, and they reverse the motion. There's actually the floor of the hopper moves back and then can move forward to move the pile as is. So I observed them offloading for about an hour also, and it was not going away. So I mean, I suppose there is the possibility for some, to be floating away, but it's very contained. I thought that it does a good job with that.
So that answers that. And the second one about maybe locations. I mean, right now you're like, kind of give us blanket authority to go and, do this process where, our contractor sees fit.
So it's, we're currently asking for an order of conditions which would allow the physical removal of plants by these different methods. If you, I think, I would see this as being, the kind of coordination that's comparable to what is done for other lakes that use herbicides, where, I believe they come in and say, this year we're going to put this down now, and this is when we're going to do it, and this is where we're going to do it, and this is why. And, to the extent that you want, coordination on that, we're happy to work with you on that. I can, before we do it, in the season, we would say, here's where we're going to be doing it, here's why we're doing it, here's what the plans are, and we can notify you ahead of time, and we can also give you a status of what happened afterward.
That work for you, Matt?
Yeah, it's consistent with, the other kind of orders, conditions for, the other water body, management of the other water bodies. Just a couple, items. This is, it may be considered a limited project, ecological limited project under 10.53, where it's, limiting eutrophication of, and management of invasive species, isn't, invasive species aren't ideal habitat, as such. Native vegetation, it is a reviewed strategy under the generic environmental impact report issued in 2004 by DEP. Also, it as kind of included as in their addenda, there is a they do identify in the practical guide to the GEIR. They do specify the impacts of harvesting, general mechanical harvesting, specific to the Wetlands Protection Act, and most of the impacts are generally neutral. There are a couple, there may be a detriment if fish are directly removed, but there may be a potential benefit if the overall habitat is improved. And as it does state, it may have a benefit and detriment to different species in the same lake at the same time, So, in terms of kind of the scope of it all, it certainly is consistent, is a accepted practice, at the state level.
And not saying it's not, and not saying it's not what should be used here. I'm just saying that, I just want to make it consistent with, how we let others do similar types of activities.
So
in town.
have this serve as a baseline for other lakes that may want to use it in the future.
Yeah.
Now-
And
Go ahead.
one last thing, in the order of conditions for, the issued order of conditions for the drawdown, Natural Heritage, we just extended it a couple months ago. One of the conditions Natural Heritage requires is that they opine in the event of amendment, extension, modification. We have submitted that request. I think their 30-day timeline ends on the 28th? 27th or 28th, which is the day after I've asked the biologists at the state level if, we could, because Littleton meets the night before ours, so if we could, have it so we don't continue it out further. And there was one comment Littleton did receive a comment from DEP that the project may not be eligible for an amended order, as it appears that the proposed work is likely to result in a greater area of impact to land under water body than was permitted in the order of conditions. The commission is ultimately the issuing authority, so, it's, if you are comfortable, progressing with an amended order of conditions, that's, I would draft new findings, new special conditions for the commission to review at their next meeting. Also coordinate them with Littleton so that there is some consistency between the two. But, I would be working to make sure that we have a robust set of findings so that, based upon the discussion tonight, the conditions approved, I think there is, I do think this, the alteration during a drawdown, the alteration of land under water body is occurring because you are lowering water levels, you're exposing different areas to different amounts of sunlight, you're exposing, you're actually, physically exposing
Different pressure.
Right, and so, while the portions of the water body with which are typically exposed during a drawdown is, a conventional area of impact, I do think that there may be, the overall water body is being impacted by a drawdown, and especially where, the proposed management is not occurring at the same time as the drawdown, that there may be some vegetation regrowth, by the September, October when the drawdown occurs.
Too, though, that some of these areas, that where the vegetation will be removed, are in areas that are going to be affected by the drawdown. Many areas will be deeper than, a drawdown would be able to, have any effect on.
Yeah, so, again, it's the, managing invasive species, and, there were, last year's survey, midsummer survey, there certainly are, there are areas of denser, invasive weeds and, or invasive vegetation.
Well, if we knew that they were looking at those and we're looking at other areas and show us where that is so we could bless that as well, that seems to be how we approach invasive weed management in the other ponds.
Carolyn, did you have
I
a?
was just going to say, if we have all the documentation and that, for after as well, I'm saying to go ahead with this, but that if you keep the documentation and we can check afterwards and see what the ramifications have been, maybe this long-term project will be something that will be really beneficial.
Yeah, and the narrative does explain where we would be targeting in the lake this year, if we're able to do it this year.
And you're going to check again at some point to.
Yeah, I mean, there are some weasel words because.
After the fact. So
After the
that
fact,
you can
right.
See what the results are from what you did.
Right, but also.
Going forward, whether or not this is the right approach.
Yeah, at the time that I wrote this, was, in June by the time they get out there to do it, it may change a little bit, but it's pretty consistent from year to year as to where these areas are that are heavily populated with invasive plants that are beyond the reach of the drawdowns, and especially some of the people at the east end of the lake and the Westford shore suffer every year, and this is I'm looking at this as a way to finally give them some relief.
To do nothing is not an answer.
Yeah.
Are there any comments or questions from members of the audience? Okay, so we're still waiting on Natural Heritage.
Yep, we're still waiting for natural heritage, but I can draft a amended special conditions for the commission to review at the next meeting if it is their pleasure.
Okay, so can I have a motion to continue the public hearing till July 26th?
So moved.
Second.
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. So, hopefully National Heritage will get us a letter before the 26th.
Yeah. Okay. Yeah.
Before summer's over.
Yeah, we'll see. I mean, worst case, we're set for next year.
Yes.
And I apologize that, we weren't able to come in sooner. As soon as we found that we had funding to do this in Littleton, we started the process. And so, I'm sorry, it wasn't, we'd have all liked it.
We'll get to it sooner or later.
Yeah, okay.
You appreciate what you do.
Thank you very much.
Thank you, Dave.
Appreciate it, yep.
Moving on to our 7:15 PM agenda item, a public hearing for Sturgis, 21 Villanova Drive.
Under Massachusetts General Law, Chapter 131, Section 40, the Wetlands Protection Act, and Westford's non-zoning wetland bylaw, Chapter 171, the Westford Conservation Commission will hold a public hearing on Wednesday, July 12th, 2023, at 7:15 PM in Meeting Room 201 at Town Hall, 55 Main Street, to consider the request for determination of applicability application of William Sturgis for after-the-fact installation of an in-ground soak pool or hot tub and reconstruction of an existing patio area within 100 feet of an intermittent stream and bordering vegetated wetlands at 21 Villanova Lane. Assessors Map 66, Parcel 104, Lot 0.
Good evening, Attorney Michael Bonifant, Bill Sturgis, Villanova Drive. As you saw in your packet, Mr. Sturgis bought this house 9 years ago, reconstructed a patio that was out behind the home, went to install this soak pool, which is a large hot tub, but even larger than a hot tub. It's in ground. It's is it a lap pool, Bill? Kind of
more of a hot tub.
More of a hot tub. Went to pull the appropriate permits and found that he needed to come before you folks on this. So he called Mr. Salem to come out and take a look at the project. Mr. Salem determined that he was within 35 feet of the protected area for the proposed soak pool. There is in your package a rendering from the landscape construction. I did shade out where the plantings were. There are going to be no plantings on the side closest to the protected area, actually either side, so there'll be no plantings. It's just the already constructed patio and then the soak pool. So the area is now covered with grass. It's a maintained lawn up until the wetland area, as it's been since he purchased the home. He's just looking to get the permission to correctly to continue on with this project.
This site, looking back through the project history, the patio, there were additional decks which have since been removed. There was a above-ground pool which also has been removed, kind of on the right by the basketball court. Those were approved previously as minor activities. There were no citations on the building permit that was signed by my predecessor, so I'm not sure why it was signed as a minor activity, but I'm believing it's beyond 50 feet to the wetland. It was beyond 50 feet to the wetland and was a minor activity under the Act. Upon going out, as Attorney Bonifant has mentioned, the lawn, the existing area is lawn, there was an existing patio, you know, it's the overall disturbance to the wetland, which is shown on the subdivision plans as a drainage easement, as it was the subdivision of the property, and the house was constructed prior to the adoption of the Wetlands Protection Act and subsequently the bylaw. So it's, I'm not sure if it would be built today, but there is a house there. It is this existing lawn area, you know, maybe even, you know, in the area the soak pool was, you know, previously a patio. So yeah, certainly previously disturbed.
Yeah, but nobody came into, but this plan isn't part of that plan, is that?
No.
So, we're in 35 feet, is that correct?
So 35 feet to the wood line. So the corner, this corner of the pool.
Right.
It's 35 feet to the
Okay.
nearest,
And what you're saying is once before it had an above-ground pool, there was existing lawn, but since then there's been installation of this patio and this soak pool?
no, so the soak pool's a part of this
Always
application.
been there?
No, there was, I think, previously patio in the
Patio
area.
and then
Yeah.
the above-ground pool.
Yeah. So the above-ground pool was over.
There's a, yeah, there's a
the-
highlighter.
the- Yeah,
Yes.
don't put it at it. Don't put it at me either.
The above-ground pool here, what did you
So the above-ground pool was right in this area right here.
right there? There was a patio previously where you replaced the patio.
was right here. In the same footprint.
In the same location, pretty much.
Same exact footprint, yep.
And now he just wants to get our blessing.
Yeah, there was a building permit associated with it, you know, and the more I looked into it and again, kind of looked at the plans on file, you know, the septic plans, you know, they do show a wetland, bordering vegetated wetland, you know, shortly beyond the wood line, but there is an established, you know, the edge of lawn, there is an established buffer of probably 5 to 10.
So he wants a certificate of compliance for this one?
No, just a determination of applicability, a negative determination of applicability.
To make it kosher.
Yes.
It was when he went to apply for the proper permits for the pool and the electrical permits that he looked at the necessity of this determination.
So is there anything more that he's trying to do here that he needs a determination for, or he just
No.
wants
He
to
just
clean
wants
it
The
up?
the pool, the pool and the, you know, reconstruction of the, patio.
Now, were the plantings removed independent of needing to do this filing?
So plantings aren't there. So that was part of the design with the new patio
So the
pool.
plantings were removed from the plan before the whole process to,
No. So once we determined that, and we discussed it, where we are and what we're doing, and that it's a sensitive area, determined not to do the plantings and keep it just lawn.
okay, because sometimes, you know, if it's native vegetation, the plantings might be environmentally more friendly than the lawn. So you know, don't think of us saying we don't want the plantings there, that, you know, depending on what the plants are, that might actually be an improvement. So that's just, you know, now's the time to have that discussion.
So what's on this side, just grass?
Yeah,
Grass.
it's just lawn.
Yeah.
And no resource area over here? We're only
Yeah, no, so the resource area continues, it continues around the back of the property, or the top of the plan, as,
And how far is he coming to the resource area with his grass currently?
there's probably about a, you know, 5 to 10, 15-foot buffer in some spots of, you know, from the lawn to, you know, and looked back at aerial imagery, it seemed to be fairly consistent back through, you know,
The decades.
yeah, the early 2000s.
Well, if we
was-
were looking for additional buffers and like what Margaret says, you know, adding,
Well, no, I'm just thinking, if he thought to take the plants out because he thought we would like the lawn
that would be
better.
better for us.
Yeah, and I think
Sometimes we prefer to have,
The plantings.
The plantings because.
And I think it was a
otherwise-
combination of things, right? So I think that was, this is what the landscaper came up with, and I think the discussion with the landscaper was, we'd like to keep it more as it is, and then maybe,
Okay.
the theory was,
Now is the time to have the
Sure. No, I
discussion
understand.
if, in fact, you had thought we would prefer the grass.
Nothing else is happening, it would stay exactly as it is
Okay,
now.
that's fine.
Yeah, I mean, nothing else is happening, he's
Yeah.
just looking to clean it up, and he's looking for a
And I'd give
negative
him-
determination. I'm okay with that.
So am I.
Okay.
okay, great.
And just the pool equipment is down, they're reusing the previous pool, above-ground pool equipment, which is located kind of in that corner,
It's
so
never been taken away,
Yeah.
it's still there. That's what they bought. I'd leave it alone.
far as could be, and that's what was there.
Any comments or questions from members of the audience? Any more from you?
Only special condition I thought of, and it's at the commission's pleasure, storage of the pool chemicals not in the shed closest to the, which, was discussed as, just cold storage of kids' bikes
So it'll be
and
a
stuff.
conditional negative.
Yeah.
Conditional negative, yes.
Can I have a motion to issue a conditional negative determination of applicability? Negative determination is good.
Good.
Yes.
Yes.
So moved.
Second,
All those in favor? Eric?
yes.
Marilyn? Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes.
Thank you very much.
Thank you.
Thank you.
Can I have a motion to close the public hearing?
So moved.
Second.
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel? Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. So the public hearing is closed. Thank you very much. Okay, moving on to our 7:20 PM agenda item, continued public hearing for Franklin 31 Bridge Street.
I received word this afternoon from the design engineer and the applicant requesting a continuance to their next meeting. They have plans which will be submitted at the end of this week, and as opposed to quickly submitting them with no time for the commission to review, wanted to make sure that the commission had the full time to review the plan, and is requesting a continuance without discussion to the 26th.
The 26th. Okay, can I have a motion to continue the public hearing to July 26th?
So moved.
Second,
All those in favor? Eric?
yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
No.
Okay. Ann?
Yes.
And Margaret, yes.
Beautiful.
Okay, moving on to our 7:25 PM agenda item. It's a discussion on required information for legal notices.
So following up on discussion from the last meeting, in my research, I found that Mass General Law, Chapter 40A, Section 11, specifies the required information for a public, for a legal notice, for an application under the Wetlands Protection Act. It requires the name of the petitioner, street address, date, time, place of the public hearing, subject matter of the hearing, and the nature of the action or the relief requested. I know at the pleasure of the chair, if you'd like to state your name for the record and, speak. I know you were seeking accommodations.
Oh, hi everyone. First, I think in relationship to this matter, I would like to ask the following: to please just generally allow privacy consideration with regard to,
I'm not understanding you. Can you just talk into the mic a little, please?
to just please allow privacy considerations with regard to any setup to be decided related to this matter. The outcome, also the second thing I would like to request is that the outcome of the deliberation from today to please facilitate the resolution of my situation as well. Specifically, I would like to ask that my name be allowed to be referenced as by homeowner in such a posting that makes it to the World Wide Web. What I would like to add to the note that you provided to the Commission is that it seems that Massachusetts has a right to privacy codified in state law. Massachusetts General Laws, Chapter 214, Section 1B. It's actually a two-line section. A person shall have a right against unreasonable, substantial, or serious interference with his privacy. The Superior Court shall have jurisdiction in equity to enforce such right and in connection therewith to award damages. Relevant to this might be the posting of the proposed activity. So this, I think we might have missed a little bit of an introduction. This concerns like legal ads being sent to a newspaper, and the concern here is that they do, it seems that they do end up on the World Wide Web. This is new to me, so I don't know all the details. But I would, just to continue what I prepared, the posting of such activities onto the World Wide Web, along with the name and home address, might be unreasonable. As it appears, this may not be mandated by law or regulation. The reference section 11 of Chapter 48 appears to indicate that the notice only needs to circulate in the town or city to satisfy the statutory requirement. I'm seeking, in my request, I'm seeking a relatively very minimum changes or inconvenience to existing process. Like, it's more like a surgical edit of what could kind of keep everything in place, but sort of satisfy the privacy requirement. For the required name part, I'm asking that the name be allowed to be signified as by homeowner in my case. Of note that for corporations, for such posting, also an individual's name is not listed, indicating that an individual's name is not needed. The homeowner's information can be retrieved, as the posting includes the address of the premises, as well as information on how to contact the Commission for Information. I have a third point that basically, I think that if you do a very strict reading of said provision, may potentially create a double standard if there's other provisions that may not be followed as stated. The most important point, I think, is that merely posting the name of a person and his or her home address on the World Wide Web can be potentially rather intrusive. In addition, the posting includes details about the home activity. Again, Chapter 48, Section 11 does not seem to require posting on the World Wide Web, but merely that the notice be included in a newspaper publication that circulates in the town or city. Obviously, it can exceed that, but when you're sort of exceeding that to the worldwide level, that's kind of a vast of a leap. Posting onto the World Wide Web appears to be a substantial broadening of the circulation requirement for this announcement. The posting the posting seemed to be, the other observation is that this posting seemed to be picked up by another site, which I have really no knowledge about. mypublicnotices.com seemed to kind of aggregate all these postings. I'm not sure if that, to my knowledge, that's not statutorily required. Definitely, I don't see that in Section 11, Chapter 48 to be required, but it is taken on by another site. It seems that the posted information also gets crawled and is shown by search engines. I would like to just add as a note that there are also many privacy laws and regulations on the state and federal level that seem to be generally applying to various situations. This seems to be in the range of tens to hundreds. I would say probably like less than 100. And many in the range of thousands of court precedents and court opinions concerning privacy. Some of these may also apply or cover similar situations.
Can I just, is he going to make a request that we want town council to take a look at?
That's
I mean, I'm kind of losing what he's saying, and I just want to.
So let me summarize, Daniel, so if I can summarize, if I can summarize for you. So you are uncomfortable having your name listed on the legal ad. No, well, name listed at, you don't want your name listed, you want in the legal ad, you would request your name be by property owner or homeowner. Secondly, you have, your concerns about things being posted on the World Wide Web. If the commission is amenable, those are the two big ones?
Yeah, just with my name.
Yes, okay, so in terms of in terms of the second point, the regulations require that the commission provide notification in a newspaper of general circulation no less than 5 working days prior to the meeting. newspaper of general circulation is, we can't post it in the Worcester Telegram and Gazette. It needs to be of, unfortunately, with the ceasing of operations of the Westford Eagle, there no longer is, a local, weekly periodical with which as we used to publish. But it does say just a newspaper of general circulation. That if, the practice, to provide information, for the residents.
Look, we're not town council. I mean,
Right, but no, but our practice has been to notify it in the print newspaper, have them add it to their online legal ad section, and ask them to publish it in the Mass Public Record, or masspublicnotices.com, which is, operated by the Massachusetts Newspaper Publishers Association, or some acronym thereof. So, in terms of complying with the regulations, where it goes, if the commission, thinks that, of a newspaper of general circulation, and just the print copy is sufficient.
it sounds like we have a general practice that we follow. It seems like we have an individual who is seeking an accommodation or some sort of relief to that. Maybe I don't know where we have the ability to say yay or nay. Perhaps that, again, needs to be a legal interpretation, because, I mean, we
I think
are
so, too.
following through and proceeding in being compliant in a certain way. And if we can provide relief, maybe we can, but maybe we just stick to the way that we, currently go about our business.
I would be comfortable with that too. I'd like to get a legal, exactly what we could provide him. That would be kosher.
With respects to kind of the two requests,
Right.
Yes.
one,
Yes.
the name being included, the
So
name being
if we
included.
can, then we will. If we can't, then you have the option not to go forward.
But the other part of it that I think we need to make is our practice has always made information available to the general public so that they know what's going on in their neighborhood, in their town. And so the other piece of it is, do we have to be held to a standard of consistently providing information to the public? So some of it is.
Well, we've been providing a certain level to the public
Yes.
because we feel that we have an obligation to do so.
We have set a precedent.
And, yeah.
But if an attorney tells us that we also have the right, in this instance, to leave that piece out, just say the homeowner, and we could go forward. If he
Yes.
says we cannot, then you have a choice of not doing it, and we can't do it any other way.
Well, he could always have an attorney provide the same thing and say, I'm not going to do this or that because I believe in accordance with this. I don't have the obligation to do so. Then he could provide it to our town council, and our town council might have a difference of opinion.
Well, I think-
But I don't see why we're getting into the middle of that to try to make this determination. Jim?
Okay. Jim?
I'd agree that we could have town council take a look at what the requirements might be for the content of a public notice, but there's multiple layers that we haven't even talked about yet. Let's say he gets his relief on the public legal notice. What happens when he submits an RDA request? It has the applicant's name, it has the property owner's name, it has your signature, and that's a public record. What if it's a notice of intent? That has your name as the applicant, it has your signature, and that's a public record also. That goes out on our meeting packets, available for anybody that wants to download it from the Town of Westford website. If people want to find out where this property is, they can take the address from your notice, go to the geographical information system, and your name and the co-owner's name are listed right there. Or you can go to the assessor's database, look up the property number, your name, your partner's name is also there as co-owners. If you're going to do a construction work and you get a building permit, or electrical work, or plumbing work, all the plumbing, electrical, and building construction permits, all that permitting is online on the in the assessor's database. Stuff is not a secret, and we don't want to keep it a secret. We want the neighbors to know what's going on in their neighborhood. The purpose for these public notices is so people can see what's happening in their vicinity, that people can contact you if they feel necessary to ask you questions about your proposed projects. Those are all the reasons. I mean, that it's done on purpose to try to get it a broadest distribution.
And transparency.
Yeah, exactly. Yeah.
Transparency.
Throw some things. These are nice responses, and I appreciate you guys providing them. In terms of the difference between something being on an assessor's website or whatever, the observation here is that the content that goes onto this website that I mentioned before seems to be crawled and shown by internet search engines, creating a different kind of access point to the public, that it is actually restricted in various ways when there's privacy involved in government databases. The second I would like to say is that we all love the idea of general transparency. However, this when privacy considerations are being brought forward, what I have seen in court cases, like going all the way to the Supreme Court, is that the court just seems to weigh to balance the two. So what is the public interest in a specific matter outweighed or vice versa by the privacy interest in a specific matter. And I do kind of feel that in this kind of case, the privacy interest would prevail, because as I mentioned before, I don't see a substantial public interest by saying homeowner or the name. The name isn't as material to whatever project you are putting forward. In addition to that, I'm not asking for the notice on the town hall to hide any names. I'm also not asking, the notices to the abusers are not hiding any names. These are concerning things that are just going onto the World Wide Web and their access in a controllable way. And again, I just want to repeat my other point, is that posting the name of a person and his or her home address on the World Wide Web can potentially be rather intrusive. And also, handing this over to a publication, it means that now you are under some publisher's rule. So you may never be able to take it down because they could say that you gave consent. What if someone is harassed? What if somebody wants to, for a lot of reasons, you just don't necessarily want.
These are bigger questions that
let's
Find out what we can do
yes.
I'll reach out to
from
all.
an attorney, and we will go from
But
there.
that's the guiding, I think, from what I've seen, is that you have to balance the two interests. You cannot just say,
And
in an absolute way, I want a full.
And we'll get town council opinion,
And
we're not, none of us are lawyers, so, we'll have town council opine on that, hopefully I'll have it in time for the next meeting. And, and then the commission can, see what, town council has.
There may be some things we cannot do or can do.
Well, I'm
And
going to
if we
follow
have to
town
do,
council's opinion, because that's why we
that's what we
seek it. So,
Okay.
what you want to protect, I get that you don't want certain information out there on the World Wide Web. I guarantee you, like Jim says, we're not the only entity. I'm sure there's lots of information about you out on the World Wide Web already that anybody could seek on Google or any other search engine. But I'm just saying, let's see what town council says, and we'll go on from there.
My Facebook, I'm totally blank. Like, you just choose to sort of not put any information on there. Like, I don't have, my LinkedIn is totally blank.
I wish the world was
I
that
don't
simple
have
that
any
they wouldn't
personal
find out
information.
about all
Madam
this.
Chair, if we can go to, I have direction to get an opinion from town council.
Yeah, right.
And if that's will that satisfy,
It is.
I don't understand what that means.
So I'm asking an attorney who's on retainer from the town
Can do.
to provide a legal opinion as to A, what is required in terms of the information in a public hearing.
legal notice.
For a legal notice. And also, could the notice be just in the physical print copy of the Lowell Sun as opposed to the,
Could we, so stipulating that the Lowell Sun does not put it,
online or,
Yeah, exactly. And that, the other thing I want to touch on is that if you actually do glance at court records regard to privacy, you do see a lot of cases that are the plaintiffs or whatever, they are using pseudonyms.
but this is where town council will look at all that and say, for this particular case, this is how we as a board should proceed.
Let me just have a sentence too, is that you see these cases called Doe versus Doe, like both the defendant and the plaintiffs just hide their identity. And somehow this is allowed, for privacy reasons. So I hope.
And there are exemptions in open, but, we are.
Things aren't, so again, you want to be treated and, you know, you are seeking certain accommodation and certain relief. We don't know if we can grant that or not, and we're gonna find out from legal counsel what we can and what we can't do. And, you know, we'll follow their recommendation in regards to the two questions, you know, we're seeking to have answered. And we'll go from there.
Okay, moving on.
So thank you so much.
Moving on to our 7:30 PM agenda item, ratifying an enforcement order and discussion of draft enforcement order for Spalding Hill Homes
Last time it was
Incorporated.
40.
Okay.
Good evening. For the record, Mark Slager from Allen Engineering, here on behalf of Spalding Hill Homes, Inc. Also with me is Joe Cataldo, the owner of Cataldo Excavating, or Construction, one of those. He is one of the two general contractors working at the site. I have a copy of the enforcement order that Matt prepared. The summary is, seems to pretty much say everything.
Could we get to ratifying the one that I issued from Friday first? Just,
You can do whatever you want. I'm just here to represent the owner.
so, I mean, there was an enforcement order I issued Friday upon inspecting the erosion controls of the Phase 3, which is the construction of the houses around the loop at the far north end of the property. The 3 areas of release were observed where runoff bypassed or broke through the erosion controls which were installed. I had photos attached. There were the items ordered were that the erosion controls be maintained and repaired, and any accumulated sediments along the wattle and silt fence be removed. I know I've received an email from Mr. Cataldo Saturday morning.
Yes.
That there was a crew addressing that at that time. The second one, pursuant to General Condition 18, you know, that the applicant provide the name and documentation of daily inspections as is of the erosion controls as required. Additionally, stamped erosion control plan prepared by a professional engineer to prevent further releases from cleared areas of Phase 3, reviewed and approved by the engineering department, and that all released sediment be removed from the jurisdictional wetland areas and adjoining buffers within 3 days of receipt. At that time, today I did receive an email from Mr. Slager engaging with Oxbow Associates to assess, or to, was it assess and prepare a plan, an action plan to remove the sediment from 2 of the wetland, the northerly wetland area beyond the limit of work, and also the wetland at the corner of Keys Road and Broughton Road, yes.
Yeah, my request was to have him assess the impacts and then to develop some kind of remedial action plan. When I was out there yesterday, I looked at the sediment at the north end of the site in the wetland, and it's still a very wet situation, and my fear was that, you know, if I just have a bunch of guys go in there with rakes and shovels, it may end up doing more harm than good. So rather than just jump in and do that, I wanted to engage someone who knew what they was doing with respect to the wetland. I did hear back from Brian Butler of Oxbow this afternoon. He's extremely busy. He won't be able to look at it for at least 2 weeks, which I know there's some timelines as far as getting a contract together and then find timelines for getting action together. And then there's also a deadline of October 31st to get the work completed. I would be more than happy to agree to those. The only concern I would have is that if Mr. Butler thinks that it may be more appropriate to do the work when things are more dormant, then the October 31st deadline may be inappropriate. I'm not sure what we should do at this point. I think maybe maybe putting in a down gradient siltation curtain across the wetlands so that further sediment that's already in the wetland doesn't get transported further downstream, as a temporary measure at least. These are just some ideas I'm coming up with now as we're speaking. But, I know the order of conditions says that any sediment that enters the wetland shall be removed immediately. I don't think that it anticipated the amount of sediment that occurred at the northern end of the site. It is very significant.
So I saw the breaches, but I didn't see the sediment in the wetland.
Yeah, so that was, that photo, I didn't actually observe the extent of it until Tuesday when I was out there. I just saw, as from the, included in the packet, there's some, this is the edge of the wetland here, and, you can see the sediment. Additionally, the velocity of the release, caused all leaf litter and branches to be cleared down the path, down gradient towards the wetland. I do have a photo of it, and I wanted to include that in my the draft enforcement order, which I provided to the commission tonight. But my phone isn't connecting to, and I can't get photos off of it, in time for the commission. Yeah.
It sounds like it's more significant than I had at first anticipated or realized.
It was shocking when I saw it yesterday, but also saw that, the erosion controls had been, improved over the weekend, and, so there wasn't, no evidence of further erosion and
the sediment that was between the wetland and the erosion controls, that has all been cleared up, and the area has been, re-raked and everything.
So the buffer zone?
Yeah, the buffer zone, but we held back from doing anything within the wetland itself until we sought
Yeah, we'd like to
expertise.
probably hear back and just find the right course of action.
Right. I mean,
Like Mark said, you don't want to have people just going mucking in there and making the situation worse.
I mean, so I could certainly add, or to be extended, by the commission, based upon, whatever.
Recommendation.
Yeah,
from,
recommendations, right.
A wetland scientist or whatever.
I agree.
Right, and we could reach out to others. My first thought was Brian Butler, because he's familiar with the site. He flagged the wetland, and
Do you have other names, Matt?
There are others. I certainly can find some.
yeah, we can find some others, but I have people.
You got people.
Yeah.
I love that
I
expression.
love my people call their people, right?
That seems something you have to do first.
Yes, and then just the draft one, which was provided, to this evening.
The one that was on the table?
One that was on the table is the draft enforcement order, as there were 4 releases of down St. Augustine Drive onto Groton Road. Dates are twice on Monday, June 26th, once on June 28th, and additionally on Sunday, July 2nd, with the silt-laden runoff entering catch basin on Groton Road and going into, discharging to the wetland west of 221 Groton Road, which is
Next to Dunkin' Donuts.
Yeah, it's the Dunkin' Donuts Plaza.
Depression.
But yeah, between 221 and 231. Additional runoff continued down Groton Road to the certified vernal pool at the corner of Groton Road and Keys Road, entering that from 2 locations. Again, I had photos of, I'll try to get those off tomorrow and included with the enforcement order. As the developer is seeking to pave the entire, pave the widening of St. Augustine Drive next week, and I think they've removed all the.
Yeah, I think they're on schedule. I haven't been out to the site today, but I know they were scheduled to strip the pavement from the first 325 feet or so.
Right, and so, with rain forecasted, I wanted it to be, to get documentation that, these these 4 releases have occurred, and that, this is maybe, with the weather that we've had, this, there is a potential for an additional release, and if it does occur, there will be, that, additional fines, additional enforcement actions may be taken. One of the other items included in the draft enforcement order is the hiring of a certified professional in erosion and sedimentation control to do, twice weekly monitoring of the erosion controls of the site as a whole. The planning board established a 53G account for similar type uses. And so, after, it takes about an hour to walk the erosion controls. The last 2 times I was out, Friday and again Tuesday following Monday's storm, because of the images coming out of, Western Connecticut and Vermont. Wanted to see what had happened on the site, and thankfully nothing had, but it takes about an hour to hike the entire property, and, so, I'd be seeking to have a certified professional, inspect the erosion control, and provide documentation to the commission twice or every other week.
That condition really isn't anything new to this particular developer. You recall when we did the Summer Village, we had a similar situation where for the first, I think it was 3 years, I think the company's name was Amac. They had a representative go out and walk the site on a weekly basis and inspect all the erosion control. I'm not sure whether the condition requiring the 53G account is appropriate for the enforcement order. It is a requirement of the stormwater permit that was issued by the planning board. They just haven't exercised that as of yet, but I would be surprised if they didn't at this point. I believe that would be up to Mr. Starrett. Although the commission could also, I believe, require it under their purview as well.
There is a special condition for, in the order of conditions issued by the commission for a 53G account to be established if third-party services are to be engaged, whereas the planning board has already done one. Additionally, there are, as Mark mentioned, within the stormwater management permit, the subdivision approval, there are some parallel efficiencies, to have one person who can provide documentation to the planning, engineering, and conservation, making sure that the erosion controls are being maintained and that there aren't any, subsequent releases.
I have a question for Matt. In your findings, it does mention that 2 releases into wetland areas were reported to you, I presume by the contractor or his representative? Like the second or third sentence or something?
Yeah, so they were reported, the first occurrence on Monday, the 26th, and then the Sunday, July 2nd. Those were reported by the health agent, and the assistant town engineer reached out to me on.
Oh, okay, but it didn't come from the contractor or his representative?
No.
And how, is that all of the releases? Because the way it's written, it says they would 2 releases to wetlands that were reported to you, but that's from Board of Health and town engineer.
So they,
Uncontrolled releases of sediment and silt-laden runoff from exposed side areas of Augustine
it was
Drive down Drutt Road
into two.
to 2 jurisdictional wetland areas.
Right, into two.
So 4
At
releases.
the 4 times releases occurred.
Okay, and those
They went-
4 releases, they were reported to you by,
The health agent and assistant town engineer.
not the contractor or his rep?
No.
Okay, I think then, in my mind, since we're the town had to be the ones finding this problem, it's supposed to be something that's monitored regularly under our orders of conditions. I think that by setting up an account to have a wetland scientist do routine inspections of the areas downstream of all the straw wattles and erosion control barriers would be a good idea.
Can I, Matt, can I address the board, please?
Yes?
Madam Chair, thank you. So, I'm Joe Cataldo from MJ Cataldo. So we built St. Paul Drive and we built the emergency access road. We're presently the contractor responsible for the work on Phase 3. Genetic Construction is working on St. Augustine. So, I have my dates a little bit mixed up, but the first rain event, I received a phone call from Henry Fontaine, a resident on Old Dunstable Road, noticed siltation coming down from the emergency access road going across Old Dunstable. I went up there and inspected it, and all the silt sacks were full on the emergency access road. We pulled those out, we put new ones in. That was the week prior to the monsoons. So we got the first monsoon, I believe it was June 30th, and my dates are a little bit mixed up. Genetti had started pulling out the curbing on St. Augustine, so the sides of the road were raw, exposed. They put check dams in with 3/4-inch stone. We had a heavy rain that day. That was the day that all the water came gushing down Route 40. That was about 1 o'clock in the afternoon. All the 3/4-inch check dams that were on the sides of the road, which is just a berm of stone going down the road to slow down the flow of water, all blew out on the road because of the force of water. I called the developer, I called Chris Finnerall at 5 o'clock, we were still there, and I said, you better get Genetti back because something has to happen. We had another event of rain. The next day, we engaged New England Stormwater to vacuum and remove all of the silt sacks. We worked on St. Paul, which is the main paved roadway. We did that, and Genetti did all of St. Augustine. All the catch basins, as well as the entrance to the vernal pool, the catch basins on Chase Road and Keys Road were all vacked with the vac truck, and all silt sacks are put in. So there's 25 silt sacks that are all new and clean. Subsequent to that, with the continuing rain in the last week, we clean out the silt sacks when they appear to have more siltation in them. So it's being monitored. Also, what's transpired since all of this has happened is, if you went up St. Augustine now, you'll see check dams along the sides of St. Augustine that are 1.5-inch stone, and you'll see check dams that are running perpendicular with the road that are 1.5-inch stone. There's more of them to slow down the flow of the water. I'm not saying it's perfect by any stretch of the imagination, but it's a lot better than it was. So the timing of what happened was just the perfect storm, if you will. What happened on Phase 3, what we didn't know when the logger was clearing the road, the trees, he ran over one spot of the erosion control that we didn't see, and it undermined the straw wattle and bent down the silt curtain, which was behind it, which I think it's shown in one of the pictures, and that was kind of the start. It's right there. That's the start. You can see the depression up at the very top where the tire ran over the silt fence, and that was kind of the start of the turbidity leaving the site. The other one was just the sheer volume of the silt. Subsequent to all of this, we had a crew working Saturday and cleaned up all of the siltation to get it away from the silt fence, and we have since dug a temporary sediment basin that is within the Phase 3 roadway for the time being, to pick up any runoff. And when Mark was out, when we had our inspection with Mark yesterday, he suggested that we put an overflow pipe in, so that will not allow that pond to overtop and create this situation again. And we've also stabilized, when we cut in the roadway, we didn't have control out, so we stumped some stumps to the left of the site, which Matt and the engineering department noted, and we have since brought in stump grindings, and Mark has pictures of those that I think they were forwarded to you this afternoon, of stabilization of the road, of the left-hand side of the lots.
I didn't send anything to Matt. I got them late.
Oh, okay. We sent them, sorry.
And that was all, and that's all outside the buffer, and that wasn't, the, source of the release, the
No,
source of the
right,
release
no.
was, the, kind of that northernmost corner of the roadway.
Yes.
It was about
But
5 feet wide.
Yeah, I think, given that right now we have a temporary sediment basin in place, which is gonna collect a lot of the runoff before it gets down to the northern side of part of the site, which is where that wetland basin is gonna be constructed. That's the area where we had the blowout, up in that area. So we've got a pond up gradient of that. And I suggested letting it fill up about 3 feet, then putting an overflow pipe in just to let the water trickle out as needed. And then, the next thing we're gonna be doing is constructing that wetland basin itself. And I've talked to Jeremy about that too, as far as possibly using that area as a temporary sediment basin throughout construction, and then finalizing it and planting it when the upgradient site has stabilized. We just talked about that while we were on site. I'll have to draw up a formal plan and request an amendment to allow that to happen, if we go that route. But I think with respect to moving forward, I think we all understand that we need to do a much better job of monitoring the erosion control on a daily basis. And if there's something that happened to it, we need to fix it immediately. And also with respect to the 53G account, if the commission wants us to fund, or wants the developer to fund an account, I don't think he'd have any issue with that, and then hiring their own party specialist to go out and monitor the site, whether it's weekly or bi-weekly, or if in any event, it should be at least before every rainfall event that's predicted too.
Eric, thinking back, at some point in the order of conditions, we had a special condition that said that there would be somebody identified whose responsibility and priority was to ensure the integrity of the erosion control and to prevent, such types of issues. I think that's, in my mind, I think that's what we need to have on this site because of.
But that's what we haven't had on this site.
Right, but I don't,
She's saying we should have it now.
I don't remember if we still got that specific language in the special conditions. And in terms of, I think that's the kind of person that we need.
In
No,
addition,
and I don't
to
disagree.
whatever they're
Yeah.
doing, I agree.
I mean, one of the things I was concerned about, and we've discussed, I think, at length, is, how tight it was, and a lot of times, we don't like to clear large swaths of area all at once because, it makes those areas susceptible to what we just saw, so.
And that this needs, I think what we're seeing between the weather events and the features of the site is we need somebody where it's their first responsibility, not their third or their fifth.
You know,
Yeah, that's condition number 40 in the order.
40? Okay.
and I'm thinking in areas that have got, there have been times we've had more than, one row of silk fence
Yeah.
in areas, it seems like certain areas need to be beefed up, and, it
Because of
takes
the
more than
slope?
straw wattle and silk fence.
Right.
And
And an extra pair of eyes might also help on that, and hands.
No, we agree with a double set of storm erosion control protection. There's no question about that on the downhill side.
I think it's a good idea to have a third party, unfortunately, so that you can continue what you're doing and they can
It's like
guide you and take care of the other.
responsibility,
And you don't, spin your wheels in both places.
Yeah,
Not that we don't
I'd love to
appreciate
see
what you're
it.
trying to do.
I wish it was there before. I wish we weren't here having to have this discussion. And, I'm concerned that we had significant release to our resource area on a project that we spent so much time trying to make sure that such an event didn't occur. And through our best efforts, regardless of our best efforts, we're here tonight talking about it. And that's something we have to think about in the future as well.
This is the perfect-
As much as we went and did and tried to do the right thing, we are where we are, and why are we where we are? It may be a perfect storm, it may be this or that, but if the site hadn't been cleared to the extent it was, we wouldn't have the conditions that we have out there today. And, going forward, when we're looking at larger sites and people just want to simply stump it and clear a project to the limits of work, we risk having these types of issues occur.
Well, and that's a good point, because I think when we agreed to start doing the tree clearing on phase 3, the thought was that the erosion control would limit the movement of the equipment. It sounds like that wasn't sufficient, that maybe something like snow fencing that was more visible so that the operator would see the limit of where he should go, and if he happened to just go a little bit too far, it would be more obvious that there was that break. And so I think in terms of when we've got challenging sites like this, we need to,
Well, I'm going to be inclined in future to point to this and say, this is the reason why we're not going to let you do clearing to the extent you want to do on a site, given what has happened. So, you can only base on, I want to base any type of recommendation or decision I make on, something I've seen in the past. Well, again, regardless of our best efforts, we're here. And, to me, the way not to be here in the future is to not allow the type of clearing that we allow, which allows this to occur given, storm conditions. And I'd say if this was the first time I've been here hearing this, I'd say, okay, but, I'm not just saying this, there have been other sites as well, where we allowed a site to open up only to run into the problem because we did.
I don't think it was necessarily the amount of clearing. It was just that the erosion control measures that were in place were insufficient to protect the runoff from the amount of clearing. There should have been a temporary sediment basin constructed before all of this rain happened. That's what should have happened. And again, if there was somebody watching over the erosion controls, that breach would have been identified and repaired too. So yeah, there were a lot of deficiencies on our end, and we acknowledge that.
No, and sometimes though, when you've got so much rain and it's open up, I've seen sites where they're trying to get rid of water and things are getting all mucked up, and it's just, to me, it seems when you open up a lot of area and you're clearing it to get, you run the risk of having this occur, and we've seen it more than once. And I hear what Mark's saying, that well, maybe in situations like this, we need to beef up our stormwater control measures and our erosion controls, and I hear that. But in the absence of that, and that didn't occur, I'm not going to be so inclined in the future to allow, the opening up of such large areas, because it can lead to impacts to resource areas.
do we need, now you had said there was something you needed us to ratify.
So the enforcement order I issued Friday needs to be ratified by the commission. Additionally, in the draft enforcement order, provided at the meeting, there were 4 items ordered. The first being, again, just maintenance of erosion controls, temporary and permanent, particularly as, the entirety of St. Augustine Drive is currently without pavement. The second was the wetland specialist to prepare a plan to assess, document, execute, and verify the restoration of the 3 wetland resources, one being the BVW northerly of the limit of work, the vernal pool at the corner of Keys Road and Groton Road, and the bordering vegetated wetlands westerly of 221 Groton Road, where runoff has occurred. And again, the timing of this, at the commission's, it can be, changed to 10 business, it's currently 10 business days. If the commission wants 15 business days, 20 business days, to try to, I was hoping Oxbow was going to, 10 business days was anticipated with Oxbow having capacity and not having to go to multiple vendors or the project team not having to find multiple vendors, with expertise and capacity at this time. So, I can certainly, be willing to entertain 20 days to each of those if that's 20 business days. I mean, that's 4 weeks of, 4 work weeks of time. If that's, but,
Yeah, I mean,
know
when I
10 was,
spoke with Brian, he said he wouldn't be able to look at it for at least 2 weeks, so I would say within, which is 10 business days, so I would suspect we could have some kind of an agreement within 10 days, whether it's just a verbal or an email or something like that.
Yeah,
Yeah,
okay.
20.
Yeah, right, again, it was,
Yeah.
Okay.
20 business days, and with restoration occurring no later than October 31st, or extended at the commission's discretion as, based upon whatever is provided.
Based upon the recommendation of the wetland scientist.
Yes.
Okay.
We were just reviewing the 4 orders, we only got to 2.
Yeah.
Yeah.
Yeah, that's good. And 3 is, and again, funds are already being maintained in this 53G account. My intent is to engage a third party for inspectional services and to inspect the erosion controls twice a week, and following any precipitation event greater than 0.2 inches while site work is occurring and unstabilized conditions persist. Reports shall be submitted every 2 weeks and that's, again, the commission's discretion into the frequency and.
Let's leave it at 2 weeks, and if we need more.
I think that
Well, no,
twice a week inspection is a good
Yeah,
idea.
twice, yes.
Twice a week, but then also
Twice a week is,
following a significant event.
yeah,
Yeah.
sure.
Yeah, because that, you might set it up to be Monday and Thursday, and then something happens Friday, and you've got the guy out there Friday. Or the girl.
And then I have an item here about if the commission desires to issue fines in under the town's non-zoning wetland bylaw. The maximum fines under the bylaw is $300 per event, during each day or event, and shall constitute a separate offense, and each provision of the chapter, regulation, or permits violated shall constitute a separate offense. If the commission, again, it's just an option for the commission to consider. If not, if there's not if the third-party inspectional services and.
Satisfied with the third party.
Okay.
Inspectional services without a fine at this time, unless there was a breach.
That fines do not, we have the ability to fine now, but we are not required to fine now or not fine at all.
I don't know that you're talking about if we don't fine now for this, can we not I don't think so, but I can get clarification on that.
Or if there's another violation or?
No, I'm just saying.
Any
it's-
future release is considered a separate.
Do we lose,
The ability to fine for these offenses.
right, you know, are there criteria by which we have to decide to fine for these releases
Now,
now versus being able to address this more holistically?
I
Or
don't.
you can fine now and then decide you want to waive the
Yeah.
fine at a later point, but I believe that you need to, you know, institute and levy the fine now, and then I think you have the ability later on to waive that, you know, pending outcome of, you know,
His restitution.
remedial efforts or whatever to, you know, take care and, you know, make whole the resource area.
Okay, yeah,
Yeah.
that certainly
I mean,
sounds.
let's say if you had 4 orders that were violated, and you could do 3, you could issue a fine for $1,200, but then you could waive that based on the outcome of, you know, activities that, you know, mitigation to the resource areas. But I think you only have a limited time to issue the fine once you issue the enforcement order, if you're going to, as opposed to delaying it.
Yeah, I'm not as familiar with.
No, I'd be,
Yeah, and
so, I
it's-
mean, I'd be inclined to issue it for 12, and then, based on the outcome, having the ability to waive it, it kind of gives you, it's put $1,200 out there, saying, hey, you know, if we can't come to successful mitigation and resolution of, you know, taking care of the resource areas, we have that fine out there. I mean, we could have it out there anyway. But I think you need to do it sooner than later if you're going to do it.
And it's 1,200 per day, right? Is it per day?
Yeah, so as written, it's, you know, there were 4 conditions, numbers 13, 18, 40, and 64 were violated as of the release. Were per release, those 4 conditions were violated, or I believe that those 4 conditions were violated during each of the 4 releases. So there was, you know, Monday, you know, at, you know, 1 o'clock, 2 o'clock, you know, Monday at 5 o'clock, you know, 4:30, Wednesday at 5 o'clock, Sunday at a Sunday. So, you know, it can be, again, multiple instances. Again, it's an option for the commission to consider. I mean, if the enforcement order.
If you took 100, let's say the max was 3 and you took 100, and you had 4 and there were 4 different releases, that'd be $1,600.
And
that's only at 1/3 of what you could fine for.
And that's only at one wetland. You know, and that can either, you know, is that at one wetland or 2 wetlands? Because it has, you know, 2 wetlands were, you know, and, you know, the releases off St. Augustine Drive entered the vernal pool at the corner of Keys and Groton, and the
And if you had 2 resource areas, it would be, and you took it at $100 a piece for each violation, it would be $3,200. Because it entered the 2 resource areas. So you could make the motion, to issue that, you know, and it would be out there pending resolution.
Defer payment pending
Impact
resolution.
both wetlands. Each release impacted both wetlands.
Yes.
Okay.
Mark, I'm sorry, Mr.
Yeah, you could issue a fine and defer payment pending resolution.
Yeah, that's what,
Acceptable to the commission.
yeah.
And you could use that language, I wouldn't be uncomfortable with that.
And I'm fine, I'd be,
So you want to make a motion?
I'll make the motion that we issue $100 per violation of the order for the 4 separate events that impacted the 2 resource areas. And that would come to a total amount of $3,200.
So
Which we
it's,
defer.
it's 4 conditions,
You had 4 events.
4 events, 4 conditions
in which you had
violated each event.
You had 4 conditions that were violated. We could issue fines for up to $300 per each of those, but we're only gonna do it for $100.
$100 per wetland that was impacted, which gets,
$100 per event, per order of condition that was violated for the 2 resource areas.
yeah, so that's 4 times
4.
4 times 4
Times
times 2 times 100.
Yes,
Yes.
Yes.
so 3,200.
Am I misreading this? It says each day or portion thereof during which a violation shall constitute a separate offense.
But that's
that mean?
when the violation occurs, one violation occurs over multiple days.
Right.
So if it gets resolved, so, you know, so for example, if, you know, something happened on, you know, Monday, and it didn't get, and, you know, it was determined to, it occurred on Monday and it got resolved on Tuesday,
It's 2 days.
it's 2 days.
Yeah,
Right.
for example, a pipe discharging.
So is it resolved enough now to?
I mean, I don't,
It stopped raining.
Oh, it's gonna rain again tonight, I think.
No, but I'm just saying,
Tomorrow and the next
the
day.
event was based on a specific storm that then started and stopped. So
Okay.
that's where we're
All right.
saying one day. Because each rain event was not spanning multiple days.
Understood. Okay.
This is,
I think that's fair, Joe.
this is the absolute, this is the worst erosion problem that I've seen, and I can't remember one worse.
and the last language of this is deferred upon successful completion of,
Mitigation, restoration
Oh,
to the
okay.
resource area.
Not deferred, I think waived, which may be waived.
Pending, yeah.
Deferred means just pay it later.
That's true.
I just want to make sure we have the option to waive it, you know, pending
Upon
successful
resolution.
mitigation of the resource areas.
Yeah, mitigation of
Rest-
impact,
yeah.
restoration of, mitigation and, well, yeah,
And resolution of the problem.
resolution.
Okay.
That way we have it in place and that way we can make it go away if we want.
With the understanding that we don't know what the timeline on it is, that we could do that, you know, I mean, if we were unhappy in 2 weeks or something like that. Okay.
Did I read somewhere that we're expecting a lot of rain between today and the 17th?
It's not a heavy amount of rain, it's just continuing amounts of rain. It's not, I mean, Mark provided a chart, we got about 6 inches of rain in a 3-day period
Oh.
when we had all these events. So it was just continuing rain for a 72-hour period that really, we had no opportunity to remediate this.
No,
Good.
and
we know
I can
that. We
appreciate
know
that,
that.
and we're trying to set this up.
Respect that. I think with respects to Phase 3, our next project there is to begin the pond at the very end of the site. Once that pond is built, that's going to prevent any erosion from going into the wetlands. But as I said to Matt on Tuesday, we wanted to wait to replace the erosion control at the very toe of the slope because it's saturated, and for us to go in there and try to pull it out right now, we're going to make more of a mess and then leave the site subject to more turbidity leaving the site, and it's got to have the opportunity to dry out. But I'm confident we can control what we need to at this point in time, and obviously with the measures that you require with the monitor and so forth, we've been on sites and that's worked very well in the past with
Doesn't sound like we're
projects.
stopping you.
No,
So, you know, we're
no,
kind
no.
of, you know, we'll set this in place, but you're gonna be able to go along your merry way.
No, we're not very way, but we're gonna.
You know what I mean, but, you
Yes,
know.
yeah. We know what we need to do.
But it gives us, you know, at least, if we
Sounds
do
like
go
we covered all the bases.
ahead with, you know, the proposed fine for the enforcement order, you know, we can waive it, but it's out there. So I guess that would be my motion, and you had it?
yes, I think I have all of that.
Yes.
But I'll also run the final enforcement order by Margaret prior to
Okay.
issuance
But somebody
tomorrow.
needs to make a second to the.
Seconded.
So second is as amended? Okay, can I have a motion to approve, Eric?
So you want a motion?
Okay, all those in favor,
Of my motion to issue $100
No,
fine
to
for
ratify-
a violation per event.
well, isn't that built
The
into
two
the,
resources, so a total fine of $3,200.
Right.
that's written into the enforcement order, so now a motion to ratify the enforcement order is amended, which includes
Okay.
your fine
Well,
language.
it's to ratify the enforcement order issued Friday and issue the enforcement order dated tomorrow because I can't get in the post office today.
Okay,
I second that.
you second, okay, can I have a, all those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. Okay. So the enforcement order is now ratified
And issued.
and issued. Now, is there anything else we need to talk about for this particular topic? Okay. It's just getting late. and I asked.
Yeah, no, thank you.
Thank you, board members.
No, sorry about that.
Yeah.
No, wait a minute, the wetland scientist stuff is all supposed to have happened within the 10 days or so.
No, we-
That was 20 days.
We've amended
Okay,
it
20.
to 20.
What about the other one? There's no time on that, is there?
The other one is
Erosion
me,
control?
I'm hiring them.
Okay.
You know, we hire,
Okay.
the town's hiring them,
engaged.
so
Got it.
it's,
Good, got it, thank you.
I love making more work.
Thank you. All right. Thanks.
Sure. Okay. So that's it for agenda items. Moving on to discussion items. Releasing the peer review escrow account for 254 Concord Road, DEP fund number 334-1810.
This was, a 53G account was established with monies funded for peer review services of a wetlands, of a soil scientist to verify the delineation. This property is at the corner of Concord and Carlisle Road. There was minimal vegetation to base a delineation off of, and so the commission approved. The wetland report was provided at the time of prior to the commission issuing the order of conditions. As the order of conditions has been issued, the monies can be returned, and if...
The unspent funds?
Yes, the unspent funds.
Need a motion?
Yeah, motion to release the peer review escrow balance.
So moved.
And I was- all those in favor, Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. Okay. Update on the Burgess Pond fishing signs.
This was an Eagle Scout project that the commission approved recently, as the candidate scout is preparing to install. He observed that the original trail location on the Burgess Trail south of the water body, there was minimal space to install. It was going to be difficult. He proposed an alternative off of the access road at the intersection of the Girls Camp Access Road and the Burgess Pond Trail. There is a memorial bench.
Hicknell bench, right?
Yes, it's just kind of off photo right.
Yep.
You know, it's probably, 5 feet from where this photo was taken. There is, I went out and looked at it, there is a potential spot kind of right beyond this first tree where it could get tucked in at, along the path. So it's not, obtrusive in the view shed, but also, it's certainly at a place where people may be, where they ultimately they could end up fishing. And so if that's satisfactory to the commission, I will respond to the scout and kind of give him my thoughts, and I may meet him out there just to kind of put a X mark in the spot.
Sounds good to me.
So can I have a motion to approve the alternate location?
So moved.
Second.
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. Donnybrook,
I have no update at this time.
so we're waiting for the, was it a mock-up or a?
Yes, they're procuring the top of the bench, the stone for the top of the bench, and we will be receiving a proof to verify the spelling prior to engraving.
Okay.
That's where we're at.
So that'll probably come in before our next meeting?
Next meeting or two.
Okay. So that's still in process. The Edwards Woods Conservation Area Restoration.
I sent the letters today, and I don't know if Noel has anything in terms of kind of an update of the plan of what's to be done out there.
I do not have an update. I've been going through the area and identifying the native species that are there and making a checklist of what needs to get taken out, but I don't have it all together for you yet.
Okay, and it just, I think this is one of those things that we'll keep under discussion items so that we kind of keep circling back to it, and, you know, when you've got the plan, then we can take the next steps, but this is certainly not something we want to lose sight of.
Great.
Okay.
Thank you for sending out that letter, Matt.
Okay, now moving on to the request for certificate of compliance.
Yes, the first request for certificate of compliance is for DP file 3341793. It was issued last May at 3 Mark Vincent Drive. They were looking to regrade an undulating backyard, install a fence, install a buried propane tank. Lee's Engineering provided a list of deviations. In my opinion, none of the deviations were substantial to the overall project. If the commission has any questions, I can.
Jim?
Just one, that retaining wall by the steps that's 11 and a half feet from the wetland, what was that like on the original plan of record?
I think it would. I think that was in. It was either 12 and a half or.
It was referenced in their letter.
Yeah, and it's a retaining wall was extended and is approximately one. Yeah, so it was probably
Just a
13. I think it was 13 feet. It was probably proposed at 13 feet, installed at 11 and a half, and again, that was previously. Saying it was lawn would be generous. It was kind of just like a disturbed dirt area,
Right.
you know,
Thank you.
at the edge of the stairs coming off the property, or off the house.
Okay, can I have a motion to issue a certificate of compliance for DEP file number 334-1793, 3 Mark Vincent Drive?
So moved.
Second.
All those in favor? Eric?
Yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. Okay,
Madam Chair, if I may. The second request for certificate of compliance was from at 41 Stony Brook Road, 3341575. This order of conditions was issued in 2013, kind of as an after the fact, as after discussing with the homeowners, they installed a garden area within the outer, 50 feet of the buffer to a wetland resource area, and they received a letter from Bill, at which point they filed with, kind of a hand-drawn existing conditions of their garden area, or, their landscape garden area. They had plantings, they had blue spruce. I looked back through aerial imagery over time. Again, there wasn't a formal plan originally submitted with the filing, and going back through aerial imagery prior to 2013, the extent of the landscaped area was consistent. And they
Do you
were.
recommend approval?
Yes.
can I have a motion to issue a certificate of compliance for DEP file number 334-1575, 41 Stony Brook Road?
Second.
All those in favor? Eric?
Yes.
Marilyn? Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. Okay, over to you, Matt.
And the last certificate of compliance request is for file number 3341247 at 41R Beaver Brook Road. And this was from about 2004. There was a proposed addition to the front side of the house opposite of the Forge Pond, and additionally, they removed a deck and added an extension on the lakeward side, but no nearer than the existing nearest point. While it has been almost 20 years from the date of issuance, when I was out there, everything looked stabilized. Again, the assessor's property card is consistent with what was on the plan, and would recommend issuance of the certificate of compliance. Jim has a question.
Jim?
If we're going to use this as the as-built for a certificate of compliance, we ought to make note that all references to proposed should get deleted.
Well, no, that was, I took the proposed plan.
Right.
You know, the existing condition, you know, I will,
It's supposed to be.
I'll annotate the assessor's card, this, you know, the foundation, you know, the floor
okay.
plan.
That
saying-
diagram is the one that's going to act as the as-built?
Right, this will
Okay.
be the, you know,
Okay.
and
As long as it's identified in the file, because this one here looks like, you know, the hand sketched one looks like it's a,
right, that was what was received, yeah. But I wanted to give some content, you know, I didn't have an engineered plan, there was nothing to, you know, and with Bill kind of doing a hand annotation for the file, for the application, I couldn't, in good faith, ask for a certified plot plan by a surveyor, so would recommend issuance.
Okay, can I have a motion to issue a certificate of compliance for DEP file number 334-1247 41R Beaverbrook Road?
So moved.
Second.
All those in favor? Eric?
Yes.
Marilyn? Noel?
Yes.
Noel?
Yes.
Jim?
yes.
Ann?
Yes.
And Margaret, yes. Okay, minutes for June 28th, 2023. Did people have a chance to review them?
Looks good.
Looks fine.
Okay, if there are no comments or corrections, can I have a motion to approve the minutes for June 28th, 2023?
So moved. Second.
All those in favor? Eric?
I'm going to abstain.
Okay, Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes. So, recording of site visits.
If you'd like me to, I can give a brief overview. Monday afternoon, Noel, Jim, Ann, Margaret, and I, along with the and Margaret, yes, we did that again. Met out on site of 81 Nutting Road with the design engineer, the property owner, and the town planner. Reviewed kind of the existing conditions of the site, the proposed area to be cut. They are coming back before the commission at our next meeting, where I'm sure we'll have, you know, more opportunity to discuss kind of the thoughts, the commission's thoughts on site, or the commissioner's thoughts during the site visit.
And that's it for tonight. Oh, one of the things that I had asked Matt about is with the enforcement order that we did for Cloverleaf Lane, a couple of meetings back where we were going to have a meeting with the homeowner to talk about the enforcement order and remediation. There's been some challenges getting in touch with them, and I asked Matt to put it onto our discussion and action item list so that we keep up with it. Yes. Noel?
The 12 North Main. that
Yeah.
Thing in the back. What's the purpose of, I mean, I get the idea, but what's the purpose of including it here? What's the
So
action
it was
item?
submitted by the site professional to, pretty certain there was a special condition in the commission's order of conditions, you know, kind of requiring a year-end, you know, kind of a summary of all the activities that occurred, you know, in a given year, just so, you know, for documentation of, you know, what was occurring. Additionally, I know pretty sure there was a special condition regarding making sure that the contaminated
Send you Angelique's
the
address.
contaminated wastes were disposed of.
750 tons.
Yeah, no, right. I mean, it blew my mind when I read that they had to ship it out on railroad cars. But that was, and we wanted to make sure that it was being disposed of properly. And again, having a, licensed site professional, kind of checks the box because, they don't want to risk their own licensure. But, yeah, it was more just to kind of share with the commission, just, here's what the results were of last year's efforts. And I recently received it.
Okay. So, if there's no other business, can I have a motion to adjourn?
So moved.
Second,
All those in favor? Eric?
yes.
Marilyn?
Yes.
Noel?
Yes.
Noel?
Yes.
Jim?
Yes.
Ann?
Yes.
And Margaret, yes.